Introducing the all-new Corolla.
The appeal stems from a temporary restraining order DFS sought against the Guam International Airport Authority and Lotte Duty Free. DFS sought the TRO after they lost the bid for the lucrative airport concession contract to Lotte, and DFS fought the airport's decision, accusing them of being in collusion with Lotte. And the temporary restraining order would have prevented Lotte from moving into the airport retail space that DFS had occupied for years. Judge Michael Bordallo dismissed the case, noting the court doesn't have jurisdiction to preside over it. But then he proceeded to make comments about the case that were unfavorable to Lotte. Lotte attorney Cesar Cabot.
Lotte takes issue with certain language that is contained in the TRO orders that were rendered by Judge Michael Bordallo, dated July 17 and October 10 of last year.
Essentially, Judge Bordallo agreed that there may be some merit to the arguments.
We are only asking that the extraneous and improper statements that were made by the court be stricken from the record.
And you're arguing that under our inherent authority, we should correct it because that was clear error.
It was false and it was clear error and an abuse of discretion by the Superior Court. Yes, Your Honor.
But DFS attorney Maurice Saw disagrees. In fact, he points out that Lotte doesn't have the right to appeal this decision, especially since they are the winning party.
A winning party cannot appeal from dicta. There's been a lot of talk from the appellants about the harm of the dicta, the issues surrounding the dicta, but frankly, the rule is clear. You don't have a right to appeal.
The issue surrounds some discussion that took place in court proceedings before Judge Bordallo. Although the judge dismissed the TRO, the parties did present arguments in court on why the TRO should or should not be granted and the timeliness of the protests filed.
You can read it in the transcript, but it was clear in the hearing that the discussion was about the merits, in particular of Protest 2. There was extensive discussion about it, not just from us, it was actually from the airport.
There's nothing in the transcript that can even remotely be construed as an admission by Lotte or by the airport, an overt concession. You look at all of the court pleadings, there's nothing in the court pleadings. But my point is there were no facts or issues before the court, and it was entirely inappropriate for the court to make the decision that we lack the authority, we lack the jurisdiction. DFS failed to exhaust its administrative remedies, and then with their next breath, decide the very issues that they just said they did not have the authority to decide. All Lotte wants is a clean slate.
The court confronted with those attacks. There's really everything from you were timely, you should have done this, you should have done that, your allegations are false, really a broad scale attack. It is what the court was responding to at the time. And I would say that if the court and if the appellants are going to take the tact that they have and are continuing to take, which is a particularly ugly form of litigation, then they should be held to that on appeal. And they should not be able to use that to make a law that impacts the Guam jurisprudence. Are we going to allow, in a motion to dismiss, parties to appeal? I don't like this language, I don't like that one, the winning party. And the proliferation of appeals in a way inconsistent with any court of appeals.